ladies and gentlemen, in the Municipal Court of the City of Duluth. My name is Charles Barrett. I am the Chief Judge of this court. This court handles traffic offenses, city ordinance violations, and a limited number of state law misdemeanor offenses. Traffic offenses are misdemeanor crimes under the laws of this state and typically have a maximum allowable sentence of up to a $1,000 fine and 12 months in jail on each count. City ordinance violations have a maximum sentence of up to a $1,000 fine and 6 months in jail. Some offenses have lesser maximum penalties, and some offenses have mandatory minimum penalties. Today is an arraignment day. Arraignment means that you are here to answer to the charges against you by entering a plea of not guilty, guilty, or nolo contendere, also known as a plea of no contest. If you enter a plea of not guilty, a trial will be scheduled for you at a later date. We have no trial scheduled for today. If you enter a guilty plea or nolo contendere plea, you will receive your sentence today. The usual sentence in this court is the payment of a fine. However, depending on the offense with which you were charged, along with your prior driving or criminal record, you could be sentenced to probation, community service, driving school, alcohol or drug programs, or even jail time. State law requires the court to collect a surcharge on each fine in each case except for some seatbelt violations. Therefore, the total amount you may have to pay will include surcharges which are not kept by the city. If you're sentenced to probation, you will have to pay probation service fees in addition to fines and surcharges. A guilty plea means that you are admitting to everything that you have been charged with. If you plead nolo contendere or no contest, you're simply not contesting the charges against you as opposed to admitting them, although nolo contendere pleas are considered to be convictions for many purposes. The sentence for a nolo contendere plea can be the same as for a guilty plea, and most nolo contendere pleas to traffic and other criminal offenses are reported on your driving or criminal histories. Under some circumstances, a nolo contendere plea may prevent the suspension of your driver's license. For example, if you're charged with no insurance, racing, driving on a suspended license, or possession of marijuana, your license will be suspended if you plead guilty or if you are found guilty at a trial. A nolo contendere plea may prevent these suspensions. However, you need to be aware that there are certain offenses that will suspend your license even with a nolo contendere plea. These include a second offense within the previous 5 years on all of the charges I just named. Also, a suspension will occur for any guilty or nolo contendere plea on a driving under the influence charge. If you are under 21 years of age at the time of conviction, even a nolo contendere plea to the charges of hit and run, leaving the scene of an accident, racing, fleeing or attempting to elude a police officer, reckless driving, purchasing or misrepresenting age or identity to purchase an alcoholic beverage, DUI, or any offense for which 4 or more points are assessed against your driving record will cause the suspension of your license even if you plead nolo contendere. Therefore, speeding more than 24 miles over the speed limit will result in the suspension of your driver's license if you are under age 21 when you come to court. Also, if you are under age 18 and if you accumulate a total of 4 or more points in any consecutive 12-month period, your driver's license will be suspended. A nolo contendere plea will count towards this suspension. Please keep in mind that a nolo contendere plea does not have to be accepted by the court. The court clerk reports most matters involving traffic offenses to the Georgia Department of Driver Services, which then adds them to your driving record. Whether or not points are added to your record is up to the Department of Driver Services and not the court. Also, whether or not your driver's license is suspended or revoked is up to the Department of Driver Services, subject to your right of appeal and not the court, although the law requires the court to confiscate your license in some cases. In most cases, it is not necessary that you receive formal written notice that your license is being suspended in order for it to be a valid suspension. With certain offenses such as DUI, you are presumed by law to know that your license will be suspended upon conviction. Also, your driver's license is never automatically returned to you after a period of suspension has ended. You must apply to the Department of Driver Services for its return, pay the reinstatement fee, and provide whatever documents that department might require, such as proof of insurance or a certificate from a driving school before the suspension is officially over. If your license is suspended, do not drive again until the state of Georgia has given written permission for you to do so. This court is a court with criminal jurisdiction, and therefore it does not determine who is at fault for a traffic accident as in a lawsuit. That is a civil matter for a court with civil jurisdiction. If you wish to contest the charges against you, you will need to plead not guilty and return another day for trial. In this court, you have certain guaranteed legal rights. You have the right to a speedy trial by a judge or a jury. However, in most cases charging city ordinance violations, there is no right to a jury trial. You are presumed to be innocent. The case against you must be proven by the city beyond a reasonable doubt. You have the right to confront the witnesses against you and ask them questions. You have the right to compel witnesses to appear in court by subpoena. You have the right to produce witnesses in your behalf and produce exhibits such as pictures or drawings subject to the rules of evidence. You may testify yourself if you wish to, but cannot be compelled to. If you are not a United States citizen, the law of Georgia requires the court to inform you that whatever happens in this court could affect your immigration status. Everyone has the right to be represented by an attorney, either one hired by you or appointed by the court if you legally qualify for one. If you are legally indigent, and if the offense with which you are charged meets the legal standards requiring appointed counsel, the court may appoint you an attorney if you request an attorney, and if you truthfully complete an application form. State law may require the payment of an application fee. You may make a request for an appointed attorney when your name is called. If you are dissatisfied with the judgment of this court after a trial, you may appeal that decision to the Superior Court of Gwinnett County within 30 days if it involves a traffic violation. If you are found guilty of any other offense by the court, you may challenge that conviction by filing a petition for a writ of certiorari in the Superior Court of Gwinnett County within 30 days of the judgment of this court. You have the right to have a lawyer to represent you in all court proceedings. If you represent yourself at a trial or at any other court proceeding, you will be held to the same standards as a lawyer. Lawyers have been trained in the rules of law and evidence, and if you represent yourself and handle your own defense, you may not understand the rules used in court. There may be possible defenses that a lawyer may know how to raise, such as defects in the citation or accusation, misidentification, alibi, or a reliance on the presumption of innocence, and you may not know enough to properly raise those defenses. At a trial or in some other court hearing or proceeding, you may wish to call witnesses to testify. You may wish to question witnesses who testify for the prosecution, and you may not know how to do that properly. You must take all necessary steps to preserve all issues that can be used in any appeal, and while a lawyer may know how to do this, you may not. The decision to testify in a criminal trial is a critical one that someone representing himself or herself will have to make without the expertise of a lawyer. Your decision about whether to waive your right to a jury trial is also a critical decision that you will have to make without the benefit of a lawyer's training and advice. For those of you that are placed on probation, the court has employed a private probation company. You will meet with a probation supervisor following your sentencing. While on probation, you are expected to abide by the terms and conditions of probation, including payment of fines and surcharges, completion of any programs, community service, and any monthly probation fees as may be assessed. Each one of you should have been given a waiver of rights form when you checked in today. If you intend to plead guilty or nolo contendere today, you must read, understand, and sign that document and bring it with you when your name is called up to the bench. You have the option to speak with the solicitor, who is the prosecuting attorney, about your case before your case is called by the court. When the solicitor calls your name, please let the solicitor know if you want to discuss a possible resolution of your case. When your name is called, please come forward. When asked to do so, state your intention to plead not guilty guilty, nolo contendere, or make some other announcement, such as a request for a continuance or for an application for appointed counsel. Thank you.